justices of the appeals court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the April 10th, 2025 sitting of the Massachusetts Appeals Court. My name is Catherine Hand. I'm joined today by Justice Marguerite Grant and Justice Chauncey Wood. We're your panel today. We have 5 cases on for hearing. My expectation is that we'll hear the first 3 cases, then we'll take a brief break and come back for the remaining 2 cases. As I think most of you are likely to know, here in the Appeals Court, we argue 15 minutes per side, no rebuttal. I would ask that when it is your opportunity to argue that you wait until the green light on the podium in front of you begins. That will go until you have about a minute and a half left on the clock. Then the yellow light will come on. When the red light comes on, that indicates that your time has expired. I would ask that you finish your answer to the question and then stop unless one of the justices has an additional question for you. There is no rebuttal in the appeals court. You'll see that we have our iPads here. All of our materials are on the iPad, so if you see us consulting that, we're looking at your case materials. That said, we have had a chance to read all of your case materials, and so you should feel free to get started with your argument as early in your presentation as you can. All right, and with that, let me call the first case. This is Commonwealth versus John Ecker, 2024 P704. I note that this case is partially impounded, so I would ask that you please not make any mention of the victim's name in the case. Okay, and if you just wait for the green light.
Thank you, Your Honor. May it please the court, Kevin DeMello on behalf of John Ecker. Mr. Ecker is socially awkward. He does not appear to comprehend social cues, and thus his behavior is bizarre. But that alone is not a crime. There is a difference between socially unacceptable behavior and criminal behavior. Mr. Ecker's emails in this case were not a crime because they were constitutionally protected speech, because he did not have the subjective understanding that his communications were harassment.
Did you make that argument? You didn't make that argument in the Counterman-Cruz argument in your original brief, right?
I did not, Your Honor.
Right. You made it in your reply brief for the first time, right?
That's correct, Your Honor.
And I can't remember, I didn't have a chance to check this. Were Counterman and Cruz decided before you submitted your blue brief?
Counterman was, but Cruz was not. Cruz was decided after I submitted my brief. And in addition, I would point out that the Commonwealth alluded to both cases in their brief.
Right, I saw that. Thank you.
Obviously, our argument is that, we didn't have, this is actually an argument that we looked at, but it wasn't something that the case law at the time I filed my brief supported. But now with Cruz, I think Cruz stands for the proposition that the defendant, the Commonwealth has to prove that not only was there, objectively that these emails could have caused someone serious alarm, but subjectively, Mr. Ecker had to have intended or had to have at least had a reckless intent, a conscious disregard for a known risk that's what might happen here. But
the defendant's motion to reconsider the finding of probation violation did make a free speech argument, right?
Yes, Your Honor.
And it's talked about fighting words and Bigelow, though it didn't cite Counterman, which had been decided some 7 months before.
That's correct, Your Honor.
So why isn't this issue waived if it was raised below, rejected by the judge, and that rejection wasn't raised in the brief on appeal?
Well, what we would argue is that the issue wasn't fully developed in the Massachusetts courts, and also Counterman applies not to criminal harassment. Initially, it applied to threatening language. We argue that that should also be applied to criminal harassment.
Cruz wasn't a criminal harassment case either.
It was not.
Right. And so is there any case law to support your application of of the Counterman Cruz line to criminal harassment?
There isn't, Your Honor. This would be a case of first impression with respect to that issue. But arguably, when you look at Counterman and Cruz, what it's talking about is speech that the Commonwealth is trying to hold people liable for criminally. That's exactly what we have in this case.
And so assuming we find that it applies, the Counterman Cruz line and its recklessness, as you argued and just repeated here, subjective understanding, your client, you say he's socially awkward. It seems the 2 most problematic facts for you are, one, that he had been convicted of virtually the same crime previously, and in a reported decision we learn about it, and that this all unfolds 11 days after the same complainant has testified against him. That second point makes it, to me, very, very difficult to understand how anybody, no matter how socially awkward, wouldn't understand that this was unwanted conduct.
So I don't know if Your Honors read the sentencing transcript, but I think it's important to consider Mr. Ecker's background here. This is a man who many years ago was charged with carrying a firearm, was federally, was charged, and was found not competent to stand trial. Now that charge carried a 15-year maximum sentence, and he was held for 20 years because he was institutionalized after being found not competent to stand trial. After he's released, shortly thereafter, he's being charged again. Also, the Commonwealth has repeatedly tried to hold him in different ways. They tried to get him on an SDP, Sexually Dangerous Persons Commitment. They tried to, or at least the Taunton State Hospital tried to have him committed based on, their allegations that he was mentally ill. And then before this probation violation, the Commonwealth is trying to hold him on a probation violation that he is then found not to have violated his probation. So from his perspective, he's thinking, they're out to get me. Why are they out to get me?
Well, what Judge McDonough had to find at the hearing was that your client had committed a new offense, and to find that by a preponderance of the evidence. Are we to assume that Judge McDonough basically didn't instruct himself on the elements of that new offense in accordance with Counterman?
I think that's correct, Your Honor.
Don't we assume that Judge McDonough knows the law?
Well, I think that that's what the case law says, that we're supposed to assume that the judges know the law, but in this case, the law is that there needs to be a subjective intent, and the evidence is that there isn't one here. You look at these emails, and all he's doing is repeatedly trying to ask this woman out on a date. She might not have wanted that. She never said, stop contacting me. And I understand that a probation violation was brought, and I actually tried to listen to the testimony that was provided there, but it was, for some reason, not recorded, and I couldn't get the recording. But looking at all the other materials that talk about it, there's no indication from those materials or from this record that she specifically said, hey, stop sending me this stuff. So from Mr. Ecker's perspective, he's charged with a violation of probation with respect to his behavior. He's found to not have violated his probation. So from his perspective, he thinks he hasn't done anything wrong. He continues to send these emails. Again, they're pretty benign. The worst one is where he adds her address and says, should I send out a search and rescue team? I understand.
I'm struggling to understand. So I don't remember from the record, and I apologize. So the sentencing transcript, you mean the sentencing transcript at the probation violation hearing?
Yes, there was a separate sentencing date.
And the history, his troubling history being held for 20 years and the effort for SDP commitment, where is that in? Oh, first of all, in your briefing, you don't focus on that at all, right?
I don't, Your Honor.
Right. So I'm struggling to understand how we're supposed to place, is that an argument in favor of the notion that he didn't satisfy the Counterman Cruz subjective recklessness standard? And you didn't make that argument. You didn't cite that evidence. Is that evidence even in the record?
There is some evidence of, not in the consideration of the violation of probation, that hearing, no, it's in the sentencing transcript that comes up. And I only brought that up in reply to the question about, he was found criminally liable for similar type of behavior. But
I mean, he was. There was no challenge to that. The reported decision of his crime, that was not overturned on competency grounds, was it?
No, but I would also argue that this is a totally different case. First of all, it's a different alleged victim. And second, the types of behavior in that prior case are not the same as this. In this case, he's sending emails asking a woman out on a date repeatedly. In that case, he's saying things in the communications letters that he's sending, like violent and explicit, and assuming that there's already a relationship between the two of them. That's not happening here. And I made those arguments in my brief, that I tried to distinguish, the previous Ecker case with this case, in that the behavior is substantially different. But I'd also argue that, as a matter of law, Ecker and the O'Neill case, a similar case, they've been overturned by Cruz because both those cases stand for the proposition that the malicious element is an objective standard, that it's what a reasonable person would find. But Cruz says that's no longer the case. The Constitution requires that there has to be at least some subjective element here that Mr. Ecker understood that there was a known risk that his behavior would cause criminal harassment. And I think if you look at, even in the light most favorable to the Commonwealth, that's just not in these emails. It's not the case. What
if in the Zoom hearing that we don't have the transcript of, I don't know who the judge was, but let's say it was Judge McDonough, and Judge McDonough said at that hearing, I'm not going to find you in violation of probation, but knock it off, leave her alone. This is unwanted conduct. Would that be enough to show his intent under Counterman?
So first of all, let me point out, it was a different judge. But second of all, I would say maybe, but that evidence isn't in this record, and it wasn't before the judge here. So at best, that argues for a remand to allow the Commonwealth an opportunity to present evidence of Mr. Ecker's subjective intent. That's what happened in the Cruz case. I'd argue that analysis in the Cruz case, where they talk about whether double jeopardy applies or whether this should be remanded, in our case, cuts in favor of this case should be vacated, because the evidence in this case, and the only evidence that's available, is of Mr. Ecker's behavior has already been presented, and it does not support.
You're asking us to infer from the fact that he was found not in violation of probation after the Zoom hearing to mean that he now thinks all of his conduct is perfectly hunky-dory and he can keep doing it, when he could come away from it thinking, oh boy, that was a near miss, I better behave myself.
I mean, I think you make a good point. It's difficult to infer one way or the other. But, I would also point out that I just lost my train of thought.
Okay.
Let me pick up, and you can jump in if you get it. But I'm still struggling. 11 days earlier, he has this same complainant is testifying under oath clearly that she's upset by these contacts from him. And your argument is essentially, I guess, under Cruz, that subjectively he needs to understand that this would be threatening and unwanted. And because of his limitations, he doesn't. It's almost as though the argument is, well, first of all, it's a competency argument, which I don't think was made is not presented to us. And beyond that, it's almost like he's immune from criminal prosecution because of his nature. But really what it is that's not accurate. What it is something like a competency argument that wasn't made.
I didn't make a competency argument, and there's a reason for that. And the reason for that—
So did or did not?
I did not make a competency argument.
Okay,
and
yeah.
The reason is that the client does not want to make a competency argument because he's afraid that if he is found not competent, he's going to be held for much longer than he would if he were found guilty.
Okay, well, so I'm sorry for him for that, but we're forced to rule on the arguments that were presented to us. And it seems like a competency argument, but and if he's not incompetent, then I'm not sure what to do with all the information you've given us, but what box to put that in. But really, 11 days earlier, this victim is complaining about what he's doing. And now, to argue that he didn't get it seems that subjectively he didn't understand. That's the test under Cruz, if we say that applies. I'm just not getting it. I'm not getting it.
So first of all, I don't think it has to be a competency argument. I think what I'm saying is we have to look at his subjective intent. And I think you've said that. We're looking at his subjective intent, and the problem is he did have this prior hearing. All I can say in response to that is, look at his actions afterwards. He's sending emails that are fairly benign. And second, I would say, in our culture, unrequited love is a trope in romantic literature. It's in Shakespeare. It's in other things. I mean, I don't mean to make light of it, but this is, in his mind, someone who's pursuing a woman who maybe is not initially receptive, but maybe he thinks he can convince her. And I think that's sort of the nature of what these emails are, is him trying to convince her to give him a chance. And one of the emails he specifically says, hey, give me a chance. You know, that's the one
In
where...
Judge McDonough's findings, he cited to the 2017 appeals court case in your client's former case. Could Judge McDonough take judicial notice of those bad acts described in that case as showing your client's intent in this case?
Well, I think he could certainly take judicial notice of what's in the case. I don't think that that's proper evidence of intent in this case. I mean, it seems to me that it's a prior bad act, and you're trying to prove that he's acting in conformity with a prior bad act, and we know that that's evidence that's prohibited. So I don't think that could be the source of, you know, a finding in this case. Are there any other questions? I think the remaining issues I'd rest on my brief if there are no further questions.
I think we're all set. Thank you very much.
Thank you.
Thank you, Your Honor. May it please the Court, Assistant District Attorney Sean Buxton for the Commonwealth, asking that you affirm the order revoking the defendant's probation. I'll start with the First Amendment issue, which unfortunately is not fully briefed. It was raised by the defendant for the first time in his reply brief. And the defendant notes that Cruz was released after his first brief was filed. However, Cruz did not change the law. Counterman changed the law as to the mens rea required to prove a true threat under the First Amendment. And Counterman was released well before the defendant's first brief, and as Judge Grant noted, before the motion to reconsider was filed in this case, and I believe even before the hearing. And Counterman requires a reckless mens rea. I believe it's the defendant must subjectively know the content and must subjectively understand the statement's threatening character. And I think in Cruz, that court was dealing with a threat to commit a crime statute, which required significantly less than the criminal harassment standard at issue here. The threat to commit a crime statute required only that the defendant intend that the statements be conveyed to the victim. Here, criminal harassment requires malice. I think the best case on the malice standard and the requisite mens rea is the O'Neill case, 67 Mass App Court 284, 292 to 293. In that case, the O'Neill court notes that malice requires a greater kind of social fault than is involved in the term recklessness. It requires a reckless indifference, whether the harm was caused or not, or a dangerous act done with knowledge of such circumstances that according to common experience, there is a plain and strong likelihood that a certain type of social harm will ensue. So I think here, aside from the waiver issue on the merits, the criminal harassment statute is different than the threat to commit a crime statute and survives the Counterman analysis as a whole. I'll just briefly touch on this case specifically. In this case, the judge clearly found that the defendant had the requisite mens rea. He found that the defendant, quote, necessarily would have known that this individual, the victim, was not interested and by not responding repeatedly had rejected unambiguously his overtures. So I think in this case, the Commonwealth proved the requisite mens rea to a preponderance of the evidence, and the judge found that the same was met. So I think even on the merits, the order survives the Counterman-Cruz analysis. I'll touch briefly on the substantial reliability issue, the authentication issue. I think here there's significant evidence that the defendant was the person sending the emails. There's the probation officer's testimony and the admission of the email from the probation officer to the defendant. That email was admitted into evidence. I think that alone would be enough to...
I have some questions for you about the authentication issue. The September 12th email, which is at RA 93, it looks as though it was sent to 3 different Gmail addresses that were various combinations of the victim's name. And then the September 13th email was sent to only one of those that had been sent to the day before. My question, I guess, is does that do anything to authenticate the email? And also, was there anything about the Zoom hearing that would have given the defendant access to the victim's email?
I think at that point I would be purely speculating, but I did notice the same thing that you noticed. If I had to guess, I believe the defendant might have entered different combinations of the victim's name, maybe got bounce backs that said this is not a valid email address until he found one that he was getting through to. How he knew that that was the victim's email is unclear to me. I didn't see anything in the original violation of probation hearing that would have given him access to her personal email address. I believe in her affidavit in support of the harassment order and in her testimony, she noted that that was one of the things that frightened her, was that he was able to get access to her personal email address as well as her personal home address. I think one of the other points that weighs in favor of authentication is that the probation officer testified that he watched a 45-minute YouTube video in which it was the defendant talking. The victim also testified that she saw the thumbnail picture of that video, which she said was a picture of the defendant. So I think there was clearly enough here for the...
Slow down and go back to that. I'm not a complete Luddite, but the thumbnail photo, I
Yes.
think what my picture of this, I don't know if it was in the record, but that she gets, the victim gets an email, and in the email is a tiny little thumbnail size photo of the defendant, who she recognizes because of the from previous court appearance and interaction with him at work. Am I right about that?
That's my understanding as well. It would have been a small picture, and because of her previous interactions with him,
Okay.
she was able to tell it was him, and that appears without her having to click on any of the links.
Right.
Because she clearly testified that she didn't.
She didn't click on the links, but in other words, right, that to me at least seems like some evidence of authentication, that there's a photo of him in the email that she views.
Yes, and I think, furthered by the probation officer saying, I clicked on that link, I watched that video, it was 45 minutes of the defendant talking, especially in conjunction with the defendant's statements in that email that he had made some videos at his studio on YouTube. So I think clearly the judge did not abuse his discretion in finding that these emails were substantially reliable and that they came from the defendant. I'll also touch briefly on the sufficiency of the evidence. Here, the defendant challenges the subjective and objective alarm. As I noted in my brief, the victim testified that, quote, all of these emails made her feel very scared and anxious. The hearing judge credited her testimony in full, and I've seen no basis to, challenge that decision. As to objective alarm, as we've, belabored the point, I think. She had just previously testified against him 11 days earlier. I think that, taken in context with his statement that he would send a search and rescue team to her address if she continued to not respond, combined with the other sort of imaginary relationship aspects, clearly makes it similar to the previous Ecker case and the O'Neill case. And so I would say that there was sufficient evidence of objective alarm. So I'd ask that this court affirm the order revoking the defendant's probation, and if there's no further questions, I'd rest on my brief.
Thank you very much.
Thank you.
Thank you both very much. The case is submitted. All right, the next case on the list is Commonwealth versus Barry A. Hansen. That's 2024 P870. Good morning. Just wait for 1 minute until the light comes on.
May it please the Court, Ann Kennedy for the District Attorney's Office for the Middle District for the Commonwealth. Good morning, Your Honors. This Court should reverse the motion judge's orders suppressing the evidence seized in the second-floor apartment and denying the Commonwealth's motion to reconsider, because the evidence submitted at the hearing established that the second-floor apartment was part and parcel of the first-floor apartment, and as such, the search did not exceed the scope of the search warrant. The warrant in this case authorized search of, quote-unquote, the first-floor apartment in Southbridge, Mass., along with its basement, attic, storage, shed, garages, and curtilage associated with the residence.
How does this case fit in with the other cases that we have that seem to favor or seem to accept searches that exceed the specific language of the search warrant, where there is no access point to the additionally searched area beyond the area that was authorized under the warrant, and those that treat, for example, two separate units one under construction, one not, as unacceptably closely linked?
This case fits kind of in the middle of those. And the reason why it does is because when the police enter this first floor apartment, they see and are in fact told that the first and second floor are being treated as one dwelling. So this is a situation where when they enter the apartment, they see that the back door to the kitchen is open. The back hallways are being treated as, in fact, storage. They're told by the defendant's girlfriend that they rent both apartments and treat both as one single dwelling. Plus, you have the 12-year-old who is living, his bedroom is upstairs. And given the way that the apartments are constructed, it is literally being treated as a house.
Hold on. So,
sure.
With all due respect, the way the building is constructed, it was constructed as a two-apartment dwelling. There's no dispute about that, right?
When I say constructed, maybe it was my phraseology, the way they've set it up. Is really what I'm saying. The way that the
defendant has rented the second apartment. That's what his girlfriend was saying.
His girlfriend also stated and the judge found the lieutenant's testimony to be fully credible, that they treated the upstairs, the second floor, as just another upstairs.
No, I get it, but it's undisputed that there were two apartments. The defendant was renting both of them, and they were treating them both as their single unit.
Yes.
Right, but
yes.
there were two apartments.
They were, but the way they had them set up,
Right.
It was a continuous dwelling.
Right, and the warrant sought a search, permission to search the first floor apartment.
The first floor apartment and the areas are pertinent there too that the defendant controlled.
Right. And on that, just one more point. I want clarification on the record because your briefing, I think, was a little unclear to me. In the back porch area where there was storage, I think your brief suggested that the exterior door leading outside was blocked by stuff.
A bureau.
Right. In fact, the defense says, no, there was a door to the outside that was a clear path. It was locked, that's true, but it was a clear path to the outside. And when you open the door, right in front of the door is a staircase up to the second floor apartment.
There were two exterior doors.
Okay.
One was blocked by a bureau, and that was a mistake in my brief. I'm not trying to say that I was trying to hide anything.
That wasn't
but
the only door.
There was a second door that was locked.
Okay, thank you.
And the second door was locked from the inside,
Right.
not from the outside.
Right.
And the way they were treating the back halls as storage areas all the way up to the second floor. And the second floor itself was open as well. And the testimony showed that the only time that they saw people entering and exiting the house was through the first floor front door. They didn't see people exiting from the second floor. And
So did anyone other than the tenants in the first floor apartment have access to the second floor apartment?
there was no testimony either way with respect to that, but based on the way the testimony went in, it was just the family that was living there on the first floor that was using the second floor. No other people were using the second floor.
But because of the way the doors were, one was blocked and one was locked,
Exactly.
somebody that wanted to get to the second floor apartment would have to go through the first floor apartment.
Exactly, exactly. So, and because of that, because of the way the defendant and his family constructed the house such that it turned itself into a continuous singular dwelling, as such, that's differentiated from Commonwealth versus Hall, for example. Commonwealth versus Hall, the owner, the defendant was the owner of the entire building. There's no contest. But the search was for the first floor. Then they found out that he also owned, I believe it was the third floor, but the third floor was not a contiguous part of the first floor.
Did the search warrant in Hall seek permission to search the curtilage?
No, it did not. The search warrant in Hall, there was no indication that it sought to search the curtilage. In fact, it limited it to certain rooms on the second floor. And then it was the second floor. And then the third floor apartment up at the top was not part of that second floor apartment. It was a separate, locked, vacant apartment.
But two questions. One, the first question, in Hall, the landlord presumably had access to the third floor because he was, presumably the landlord was supervising the renovation of the third floor, right?
Yes.
Okay. And he was the guy they were searching, they were executing a search warrant for his property.
Yes,
Right.
but in that warrant, there's no indication, there was no curtilage argument made,
And that's
there's
my
no
question.
indication.
That's my next question. What's your best case that curtilage means another apartment?
Curtilage meaning another apartment, I couldn't find one that said it did. I could not find one that said it did not. But my best case for that is actually written by the same judge who wrote Hall, and that's Justice Kaplan, who wrote Pilata. In Pilata, which appears to be a rescript, they had a search warrant for the first floor apartment. And Justice Kaplan indicated in that decision that the second floor, 2 rooms on the second floor, because they were a practical and integral part of the first floor, they could be searched.
Right. That's what I call a Philly-style apartment, where it's if I'm understanding accurately I haven't read the case, but if I'm understanding accurately, I've been to Philly-style apartments where the first floor gets 1 or 2 rooms on the second floor, and then the second floor gets the rest of it. And there's a stairway that goes up, and it's clearly treated, they're separated, they're walled off from each other. There's no way to get into each of these apartments. But here, we don't have that. We have 2 clearly different apartments.
And I understand, but in Pilata, they don't describe the apartment the way you just did.
Okay.
They don't say that, and they don't say that at all. And Justice Kaplan, in writing in Hall for the court, indicates that just because there's 2 separate apartments does not mean every single time that that second apartment cannot be searched. There's a footnote in Hall that point blank says that, and says that there are circumstances such as the matter of U.S. versus Evans, which did involve, even though it's not a curtilage concept, did involve that an attic that was attached to a completely different address. And because that attic was, I guess, purloined by the first address and shut off from the second address, that it was considered part and parcel of the first address.
Right. Correct me if I'm wrong. The Evans, I think, is the case where they bust through the tenant of the apartment that takes over the attic, busts through the wall, and then gets the attic, takes over the attic from the second apartment,
Yes.
and then seals off the however you get out of that attic going down to the other apartment, right?
And it implies that the other apartment was actually occupied by someone else as well.
Right. So,
Right?
but that's different than this case because it's nothing sealed off, right?
Well, I guess I'm going to, just because it's not sealed off with plaster doesn't mean they weren't treating it as such. They had a bureau blocking a doorway. They had the other doorway locked inside. They had all the doors open such that you could go up and down the stairs at will, and they were treating it as the testimony showed, another floor.
Let me ask a different
Just
question.
an upstairs, in fact, is the quote.
Right, right. Let me ask another, this concept of spillover. I think spillover is referenced in Hall and then in Scala. And my understanding, although it's a bit unclear, is that spillover of criminal activity. In other words, it's not spillover of living, but spillover of criminal activity. And so in other words, I think the analogy in this, or the application here would be, was there any evidence in this second floor apartment that was obvious, that criminal activity was found in the first floor apartment that spilled over into the second floor apartment? Was there any evidence of that?
In plain view, no.
Okay, all right. And is that relevant to your argument?
I don't think it is, and it's more because, again, this was treated as a singular dwelling. And because it was treated as a singular dwelling and the police had probable cause to search, they could search the whole dwelling. So with respect to that, the Commonwealth would also just like to reference the cases that the defense counsel cites to and explain how those are really very distinguishable from this situation. Two cases that he cites to, and I apologize for my pronunciation ahead of time, is United States versus Vostianiuk and Berchansky. In both of those cases that he cites to as indicating that you can't treat the second, a different apartment as the same. And those situations are very different. In those situations, the police had received a warrant for one apartment due to an IP address. In both of those situations, they didn't even know who the defendant was who they are searching. The police show up at the particular apartment that they're supposed to be searching and find out that the defendant doesn't live in that apartment, but actually lives in a different apartment that's not in any way connected. The two apartments not in any way connected. So they search the other apartment. Those situations are not applicable to this one, which again, the Commonwealth's position is it's a single-family dwelling. And the police at the time that they obtained the warrant had no knowledge that it was being treated as such.
Can I ask a different question? So I think, make sure I got my facts straight. They get up to this, the cops get up to the second floor and they see a padlock on a door. They want to go through, they are suspicious. They call where the defendant is being arrested and say, hey, did you guys find any keys? Why, yes, we did. Bring those keys over here. They bring the keys over and then they use the keys. They unlock the padlock and away they go. During all of that, why couldn't the police go back to the magistrate and get a second warrant? Was there anything, and was there any reason to believe they wouldn't have been able to get a second warrant?
Obviously, I'm smiling because that if they had went and gotten a second warrant, we wouldn't be here right now.
Right, of course, but I'm being serious. I'm not being flippant. Is there a reason? I mean, if there is a reason, sometimes there is a reason. Like
no, there isn't. And if there was a reason, I would definitely be saying it to the court. But no, there was not a reason.
What about the 12-year-old boy in the towel?
The 12-year-old boy in the towel, they actually had brought him upstairs so he could change. Oh, do you mean showing how that means that the two floors are connected?
No, my point is that in Hall, there was no one else present in the house. And so for the police to secure the premises would not have inconvenienced anybody other than the police to have to post a guard. In this case, we had the 12-year-old boy in the towel and the girlfriend and maybe 2 or 3 other kids who would have had to leave the house for a period of time for police to get a warrant.
Yes, they would have. And Your Honor, that unfortunately was not an issue that we raised below, and that was not put into the record in terms of that being an exigency.
Thank you very much.
Thank you very much.
May it please the court. May it please the court. My name is Charles McGinty. I represent the appellee Barry Hansen. On behalf of Mr. Hansen, we submit the court should affirm the ruling of the court below, which suppressed the search of the second floor apartment with a warrant authorized search only of the first floor apartment. I want to discuss the configuration of the apartment so it's clear exactly what was what. The building at 30 Goff Street was a 2-family house. It was recognizable as such. That's evident from the warrant. It had mailboxes in front which denominated the apartments as 1 and 2. It had separate entrances at the front to both apartments. And I'm going to refer now.
Where's the evidence of the second?
I will address that right now. The Commonwealth's brief on page 23 says the second floor did not appear to be accessed except through the back enclosed hallway. Notice the word did not appear to be. In fact, the evidence from the transcript, and I refer now to the transcript at 11, can you see exterior staircases on the front of the building? Notice, staircases, plural. Answer, yes. The court then found, and I refer to Record Appendix Volume 1 at 44, quote, the front of the building has stairs to access the second floor apartment. There was access to that apartment in the front, both on the first floor and separately on the second floor. There was access or egress in the back, down the stairs, through the back door. The apartment, each of the apartments was equipped for independent living. They had kitchen, bath, living room, and bedrooms. The target apartment was identified as on the first floor. The clerk magistrate, oh so careful to make sure that there was no misunderstanding about what the target was for the warrant, had penned in, not in his own hand, but in the hand of the affiant, penned in first floor apartment, and that was then initialed by the affiant, and in turn was initialed by the clerk magistrate. The clerk magistrate making sure in a case where particularity matters, and being oh so particular himself, ensure there was no misunderstanding about what the target was of this particular warrant. So in sum, we have a distinct apartment, and a distinct apartment requires a separate warrant. We know that from Hall, because Hall controls this case.
Why does a distinct apartment require a separate warrant?
I will, different apartments in a single building are as distinct as separate dwelling houses, unquote, Hall. Quote, the authority to search is limited to the place described in the warrant and does not include additional or different places, unquote.
If the padlocked room had been in the basement, would the search warrant have included it?
If the padlocks had been in the basement, then arguably the issue of curtilage would be implicated, because that may be curtilage to one of the apartments. Now, if it's not, if there's two separate apartments, then it is evident that they would not have known which apartment it was associated with, and to the extent it's associated to the second apartment, or maybe they would have no authority to open it. So here, the Commonwealth's argument rests on a legal error, and it's a fundamental one. The argument that separate apartments become one because of the manner of their use. Information learned by police during the course of a search does not augment probable cause, nor does it increase the boundary or alter the boundary of the search. Hall says this. Kensington says this. In Hall, police learned during the search of the second floor apartment where the target lived that the target was also using the third floor apartment.
Why didn't this defendant's blocking off the back door with a bureau and locking the other back door from the inside transform the second floor apartment into curtilage of the first floor apartment?
Well, first of all, there's no case that says an apartment can be curtilage of another case. In fact, in Scala, the court held that a search of one apartment does not permit search of a totally different apartment.
But isn't that usually because the totally different apartment likely belongs to, is being used by a different person who has a reasonable expectation of privacy?
So there is surveillance here to some extent. And the surveillance is particular at the times when Mr. Hansen is going in and out of the apartment in connection with drug dealing. There's no larger surveillance about who's going through the entrance from the front into the second floor apartment. They have no information whatsoever about what activity is going on in the second floor apartment. They have no probable cause set out
How,
in the
from the
warrant for
photographs,
second
how
floor
would police develop that information?
They would have developed it by further surveillance. They would have developed it if they had noticed anything in the second floor apartment that reflected activity that was a basis for potential probable cause.
How would they do that if the occupant of the first floor apartment was exclusively using the second floor apartment as the second floor, essentially, of his home?
Well, that begs the question, how is there probable cause then for the second floor apartment? So here, you have an entrance to the apartment from the front. In the rear, you have a staircase that goes down. You have a door that is accessible. It can be opened, it can be closed. A person who goes in the front door has an election. Do they go out the back door, or do they go in the front door? To the extent the back door is locked, access to the second floor is from the front.
Where do you get that? Because the search warrant, the photograph incorporated in the search warrant, has annotations that say side entrance leading directly into target apartment, front entry door leading directly into target apartment. I don't know where in the record we have any information that there's any door that's to the second floor that's not blocked off or locked from the inside.
Well, what you have, there's a photograph that shows the front of the building. The photograph is opaque. If you look to the left of the steps that lead to the landing to the first floor entrance, there's a sort of a build-out there. And if you look, you could see the outline of the staircase going up to the second floor. So that's the front entrance, or what they characterize as the front entrance.
So we should infer that there's a door?
No, you're not inferring it. The judge made the factual finding that there was an entrance to the second floor that was evident, and so found it. And the point here, quote, the front of the building has stairs to access the second floor apartment. That's a factual finding made by the judge. And you have the testimony that there were entrances. Can you see exterior staircases on the front of the building? Answer, yes. The court may say, we don't have the clarity that maximally we would like to have here, but you have a factual record that says that there was an entrance in the front of that building to that apartment.
I'm just, RA, second volume of the RA 29 is
Sorry?
RA 2:29. Second volume of the record appendix 29. I think that's the photograph that you're referring to. I just want to make sure we're all on the same page here, because I can see the small staircase going to what seems to be a porch and a door, which I think is the front door of the first floor apartment, and then you can see an extension and a staircase going up to what seems like the second floor, and I think maybe, well, that's what I'm sort of asking for help. I'm asking for clarification. I don't want to. That's where it's located. Right, okay. And this other door that the judge's findings refer to, what's the record site to the judge's findings?
So the record site to the judge's finding is Record Appendix 1 at 44.
Yeah, right, okay, all right.
And that is in the judge's
Right.
findings.
Thank you.
And where's
So-
the transcript or other evidence that that's based on?
The transcript is at 11, page 11. So to my point, both Hall and Kensington both make the point that evidence or findings that police make during the course of a search does not augment probable cause. It doesn't expand the boundary of the search. Hall makes that plain. The argument, equivalent to the argument here, which is that the apartments became as one, the argument in Hall was the third floor apartment was but an extension of the second floor apartment. Hall rejected that as not persuasive. In Kensington, or Canington, whether two adjoining buildings were used as one or as a single unit, Canington called that reasoning unsound. Why? Because the Fourth Amendment says that crossing the boundary that's set within a warrant requires a further warrant. Why? Because within the warrant is probable cause for a place, for a particular place, not for some other. If you go beyond the bounds of the warrant, you are proceeding warrantless, you're proceeding presumptively unlawfully. So in Kensington and in Hall, the court is making plain that the boundary of a warrant is not something that police develop. It's not something malleable. It doesn't change. Police don't make their own judgment about probable cause. You go back to the magistrate judge, and the magistrate judge set a boundary, and it was firm, first floor apartment. Here, the Commonwealth argues curtilage. But again, there's no case saying an apartment can be curtilage to another. And in Scala, we have the answer to that. And that is that a search of one apartment does not permit search of a totally distinct apartment. Why? Because in Scala and in Wallace, those cases dealt with spaces that were appurtenant to an apartment, but not themselves an apartment. And notice in Scala, the SJC introduced that clarity into the interpretation of Hall. But in those cases, the police conducted surveillance of the buildings. They were two-story houses, didn't realize that the second floor had access to a hitherto unknown attic space. It was pertinent to the apartment, and in Scala, the court said there was no other apartment adjoining that. But it wasn't.
Your opponent will say that the difference is that here, yes, it was clear. Maybe she won't concede this, but let's say it's clear that there are two apartments. But once they get in there, it becomes clear that this is treated as a single unit. It's overwhelmingly clear that it's treated as a single unit. So what's the answer?
But that's precisely what was rejected in Hall, and it's precisely what was rejected in Kennington. What police learn while they're conducting a search does not expand probable cause. It does not expand the boundary of a search. And both those cases hold that. And by the way, there are a number of other cases cited in Hall to the same effect, as well as in Kennington. So there's not license on the part of police to go, hey, I think we've got enough, let's move on. And in Hall, what you had was police officers who hear information, inculpatory information about the use of the third floor apartment, by the same target, the information coming from informants while they're conducting the search. And the information is that apartment is being used not only as a stash, but also for further drug dealing. So now they have additional information, inculpatory information of a kind different from anything in this case. And they hesitate. And the court in Hall, the SJC, commended them for hesitating, but then said, when you went forward and you searched, you violated the Fourth Amendment because the warrant has a boundary and you can't exceed that because the authority to search is limited to the place described in the warrant and does not include additional or different places. But let me add one more ingredient to this, which is that the argument that the second floor apartment was curtilage to the first leads us to rather an absurdity. And that is that a warrant so carefully and expressly limited to a search of the first floor apartment is now perversely viewed somehow as opening up opportunity to search yet another apartment, exactly what it forbade.
Is the judge's conclusion that regardless of how the defendant used the two apartments, the second floor apartment was not part and parcel or a contiguous part of the first floor apartment? Is that a finding of fact or a conclusion of law or a combination?
That's a combination. It relies on Hall, it relies on Kennington, and the distinction in Scala, which deals with something that is pertinent to an apartment, is the language that says that this doesn't apply to a, quote, wholly distinct apartment. So an apartment is not pertinent to another apartment. It's not joined with another apartment. And if I might, The facts in this case are on all fours with another case that this court itself has decided. This is Commonwealth versus Jesus Santiago, a panel which included 2 future SJC justices.
But that's unpublished.
It's unpublished, but it's persuasive. And it's persuasive because it's these facts exactly. Police were completing a search under a warrant on the 2nd floor when a person present asked to go up to the 3rd floor to retrieve some belongings. The police followed her up. Exactly the facts here.
I think we're going to have to leave it there unless there are any other questions. None?
I'm sorry, I thought I had a minute left, but I'm over?
No, the red light is the end. You're a minute over.
My apologies. I commend that case to the court, and I ask that you affirm the ruling of the court below. Thank you.
Thank you. The matter is submitted. Okay, our next case is Commonwealth versus Jeremy and Sanchez, 2024 P0813. This matter is partially impounded. My understanding is it's based on sealed information, so I would ask both counsel to be aware of that fact and not to discuss the impounded information.
Good morning. May it please the court, Joseph Assone for the appellant, Mr. Sanchez. I have 4 issues for the court's consideration today, and we'll start with the first one. Just preliminarily, I would state that this whole case seems to me to be one where, you have circumstantial evidence, and we know what that's defined as, and then you go beyond circumstantial evidence to supposition and conjecture, and in my view, and I think even perhaps in the trial judge's view, the case was so weak because it really was right on the precipice between reasonable inferences that you could draw based on established facts and supposition. And so that's how I would open my remarks. It's interesting because the first issue I just argued it 48 hours ago in the other courtroom. The only difference in this one is that you have 2 people. The first person, Ms. Conway, ran the names, and then when she ran the names, she gave the list of names to the person who actually ran the database search, and it came up, no license. Well, in my view, excuse me, that seems to be pretty much the legal logic behind Commonwealth versus Encarnacion.
So your complaint is that the testifying witness used a name provided by someone else?
Yes, yes. And that's exactly what happened similarly in Encarnacion.
No, well, respectfully, that's not the way I read it. I read that they're clearly different. I understood that, and correct me if I get the facts wrong, Encarnacion, the problem is the person who actually ran the check. There's only one person in Encarnacion who ran the check, and that person didn't testify. That's the problem, the hearsay, the constitutional problem and the hearsay problem. Here, as I understand it, they both ran the check. Conway didn't testify, but the fellow who did testify ran his own check, right?
Yes, but she ran a list of names and came out with a name that she thought was, the right name, and then gave that name to the person who ran the...
But they're always given a name. That can't be a problem. Whoever's running the CJIS check is always given a name themselves. How can that be dispositive?
Well, perhaps she gave him the wrong name. I mean, the guy's name was Jeremy, spelled J-H-E-R-E-M-Y. A lot of people don't spell it that way. They spell it the other way.
Okay.
They do have a Soundex system that they use, and that's why she gave him a list of names. She just didn't give him one name. She said, here's the list of names that popped out, and I think it's this one. Well, if she were subject to cross-examination, you'd say, well, why did you think it was this one? It popped out a whole list of people, and you're picking this person here. Why didn't you pick the other ones that the system popped out?
There's no dispute that they ran the person with the exact same spelling as your client with the same date of birth. The fellow who testified.
Well, that's what he testified to, but he testified the name was given to him by someone else. Now, I don't know the name that she picked out.
Right, but
how she arrived at that.
Right. Okay, I've got it.
Okay.
Thank you.
So to me, I mean, our Encarnacion was harmless error because he told the cop he didn't have a license to carry. If there are no more questions on the first issue.
I just have one other
Yes.
question. Is there a challenge that you're making, I didn't see it, but maybe I'm wrong, about the submission of a report that the non-testifying witness prepared at trial? Did
Well,
that come
she
in?
gave a report in terms of a list of names, and that report was given to the fellow who actually ran the database, and the database coughed up no record found. To me, that's testimonial hearsay. So, the second issue that I raised that the evidence was insufficient to convict the defendant possessing a firearm without a license to carry. Putting the license to carry aside, we have two problems here. One is identification. Now, as I said, I argued a similar case 2 days ago. That case, there was absolutely no question who had the firearm. The cops found it in his pocket. Case closed. The only issue was, did he have a license? Here, the weapon was never found, number one. Number two, the video, the very first video where you see this black thing sticking out of the window, is that a firearm? Is that a weapon that has a barrel less than 16 inches long? I don't know. It's pure supposition. Okay? Maybe it was. The other thing is, which is very important to that issue, to that point, is that the police officer said that the spent shell casings that were found in the street, those could be chambered in a semi-automatic pistol or in a rifle. If he said, no, those can only be chambered in a semi-automatic pistol, there's no rifle I know of that chambers that round, then I wouldn't be making the argument on that particular point. But those rounds could have been chambered in a rifle. And again, I looked at that video, and even the police officer said I mean, you can't tell what kind of car it is. You can't see any people in the car. It's a million different reasons. All you can tell from the audio is that, there's bang, 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 and you have shell casings on the ground. So how do we know that that's a firearm under the statute with a barrel less than 16 inches? It's pure supposition. Again, they never found the weapon. The third issue is the search of the safe. Now, they search the safe and they find a magazine that has rounds in it that are similar to the rounds found in the street. Again, and I can't emphasize this enough, they never found the firearm that discharged those rounds in the street. The rounds that were in the magazine were obviously unfired, so you can't give them to a tool marks examiner and say, where'd the firing pin hit? Because the firing pin never hit the ones in the.
Yeah, but the Commonwealth's argument here is, I believe, that the defendant is seen pulling up to the apartment building where the safe was located, and it was the driver's brother's apartment. Oh, actually, they both lived in the apartment. The driver and his brother lived in the apartment. The safe was found in the brother's room, and so it's clearly relevant information in a gun case that there are bullets, cartridges in these guys have access to those. Isn't that relevant?
How do we know? Well, it was the brother's safe. It wasn't Mr. Sanchez and the other.
But on a relevance standard, you're saying that's not relevant?
It would be relevant if there was evidence that my client had the combination to the safe and that he was given permission to go in the safe. But I mean, the reason you put stuff in a safe is because you don't want other people to get to it, okay? And if other people can get to it, just put it on the shelf. Why bother with a safe? Again, no firearm was ever found. So how do we know that even assuming arguendo that it was a semi-automatic pistol that we see sticking out of the window of the car, how do we know that's a Glock? Because the magazine is a Glock magazine. And you can't take as the officer said, you can't take a Glock magazine and put it into another semi-automatic pistol. It won't fit, it'll jam. Okay, so you have a Glock magazine with rounds in it, and you have rounds in the street, which could be fired out of a rifle, and we've never found the actual firearm, so we don't know if the firearm, if they found the firearm and it was a Glock firearm, that probably wouldn't have made the argument, I mean, it would be pretty strong, but you don't, The other point is, in terms of, the conditional relevancy, I think the way I read the case law, that's the judge's purview. He shouldn't be giving it to the jury, a bunch, 6 or 7 lay jurors. It's, he should be doing that, okay? And, by the standard that he would use, there's no way that you could reach that point that, oh, it's relevant, it's circumstantial evidence that, Sanchez had a gun that wasn't even in his buddy's room, it was in his brother's room, in a safe. I mean, how extenuated do you want to get? That's the point. And finally, I think that's, does anyone have any questions on that? I don't think anyone does.
No, I think we're
Yes?
set.
I'm sorry.
No questions.
No questions. Okay. I would just throw out for the court, as I said, I argued the CGIS inquiry 2 days ago. And at the end of the argument, Justice Vono said, do you think we should not decide this issue until the SJC comes down with the Commonwealth, I think Commonwealth v. Smith? And I said, that might not be a good idea. So I would just throw that out to the court, perhaps. Somebody may want to trade some notes with Justice Vono on that. If there's no other questions, then submit on my brief.
Thank you very much.
Thank you.
Commonwealth?
Good morning, Your Honors. Matthew Petalano on behalf of the Commonwealth. May it please the Court. I have a slight correction to my brief that I would like to bring first to the Court's attention, but it concerns the impounded information, so I'll be a little cautious about this. On Record Appendix 12, the second January 16th entry is correct as far as the convictions and the sentencing, and I misstated that slightly in my statement of the case. Turning now to the issues on appeal, I'll start with the Sanchez argument. First off, treating Kevin Scalpin's testimony, the appellant counsel noted several times that there was a list of names provided to Kevin Scalpin. That's nowhere in the record. What is in the record is that they ran the same test, that the test that they ran was identical. They both ran a specific spelling of a name and a date of birth that is in the record in Kevin Scalpin's testimony.
When you say it's in the record in Kevin Scalpin's testimony,
Or-
isn't it also in the record in Exhibit 10, which was admitted as the printout that the witness did?
Yes, Your Honor, and unfortunately I didn't have the one with the exhibit sticker, so I did not submit that as part of my supplemental record appendix. But my understanding is that Sanchez does not provide a list of names if you put in some sort of input. What Sanchez does is you put
But that
in,
Exhibit 10 is in the record, it's in the trial record.
Yes,
and
Your Honor.
we need to get that.
yes.
Okay.
So for that reason, there's no confrontation clause issue, there's no hearsay issue. They both ran identical reports. As to her report, the Commonwealth concedes that there is a confrontation clause issue where she did not testify, but where it's duplicative of the uncontested testimony by Kevin Scalpin, I would posit that it is not a substantial risk of a miscarriage of justice. If there are no further questions on that issue, I'll move on to the sufficiency arguments. And I will say at the outset for all three sufficiency arguments that the evidence is viewed in the light most favorable to the Commonwealth. It's a very well-known standard, and the inferences need only be reasonable and possible.
Right, so this is, to me, this is important, and it comes down to focus right in on that first moment in, I think it's Exhibit A,
Sure.
the video, and that blurry car in the upper left-hand corner, we're led to believe is the defendant, and accepting that there's evidence on the standard you just articulated that he's in the front passenger seat.
Sure.
I do struggle with, and I think that the polls are reasonable and possible inference, as you just stated, but not, on the other hand, conjecture or surmise.
Sure, Your
And
Honor.
if we agree that those are the two polls, I struggle with understanding how, where there's no firearm recovered, and this testimony is these cartridges could have been fired from a rifle over 16 inches and a handgun, how we can say anything other than by conjecture or surmise that this was a handgun as opposed to a rifle. What's your argument there?
So my argument is that the jury has a common sense understanding of the size and proportions of other things in the video. They had that video for their viewing in the deliberations. They could have rewatched it over and over again until they were able to make that determination. And also, Your Honors, I did not put this in my brief, but I would point out that the video B, which is only seconds later, that fixture is not, it's not a fixture on the car. It's not seen, someone struggling to put something away. I think there's an inference to be made that it is something small and concealable, where only seconds later it is not in view on the next camera.
What in video A provides the size comparison that the jury could focus on?
Sure. So there's several fences that it passes in front of. There's a couple signposts, I believe, that it passes behind. And there's also the car itself, right? Essentially the size of the black pixels. I will admit that it is a close case, but I would say that those are reasonable inferences, that it is hideable because it's no longer there. It's not a fixture because it's not there later. And it's also not a dead pixel or some artifact of video because it follows the car as the car moves.
I have a question for you about your brief at page 21. Sure. It says, although not always, this is in reference to video A, although not always visible, the ground on the left side of the car is often covered in snow, which allows the object's size to be seen as the car continues to move. No citation. As I understand it, video A is about 10 seconds long.
Yes.
So are we supposed to just watch it over and over again until we see what it is that you say that happened in that sentence? Or why didn't you give us a minute and a second for us to find what you're talking about?
I'm sorry, Your Honor. Unfortunately, the video is so short that it is, my video software is not able to hone in on it more than the video would be able to. It really comes down to a matter of milliseconds that this thing is on the screen. And unfortunately, my video software is just not sophisticated enough to do that.
So ours is, and with the help of younger people, I was able to watch it slowed way down, able to watch it over and over again, and I'm struggling. I don't want to be flippant. I'm struggling to not be the 13th juror. That's not my job. My job is, I think, to do what you said, figure out whether a jury with appropriate deference could come to a conclusion based on a reasonable and possible inference. It could be a reasonable and possible inference that this was a handgun as opposed to a rifle, and is it conjecture and surmise? And I watched it many, many times, slowed down, zoomed up, and it's a blob. And I don't know. I just don't know. And so help me out.
Sure, Your Honor. I will admit it is a very close case, but unfortunately, I'm going to have to go back to the fact that you can see other things in this video. You can compare those. The mirror of the car is visible, the fence is visible, the signs are visible. People have a relative understanding of distances and how things get smaller as you view them. So unfortunately, all we have is that black blob, but we do know that that black blob fires bullets, right? The bullets are found, the shots are heard, things like that.
I'm with you there. I agree with that.
And so I think the black blob being seen in comparison to those things, although you can't see the details of the firearm or anything like that, I think that in conjunction with the fact that seconds later it's not seen is enough to surmise that it is small, hideable, and can be quickly moved around rather than a rifle awkwardly hanging outside the passenger window.
Thank you.
Yes. If there are no further questions on that, I will briefly touch on the same car and the same person sufficiency arguments. There's some excellent detective work here. After video A, video B happens seconds later. The detective finds some unique identifiers.
When you say it happens seconds later, your brief relies on the testimony of the detective that talks about his opinion as to how long it would take to get from video A to video B. Why not just say in video A, in your brief, the car was seen at 9:21 and however many seconds. In video B, the car was seen X miles away at Y time. And let us do the algebra, distance equals rate times time, instead of having to basically just take the police officer's word for it.
My apologies for that, Your Honor. I admit that my brief could have been more clear. I was a little worried about it being 20 pages of just video B, video C, video D, things like that. That being said, many of the videotapes, the timing that is stamped on the camera is slightly off. So unfortunately, what we have is the officer's testimony saying, I looked at the video, I looked at my watch, I said that the timing was off by ever so much. And so for that reason, we are reliant on the officer's testimony as to the timing of it. Did that answer your question?
I have a related question. I think I didn't get a chance to watch all the videos and trace from end point to start point, but if you could help me out, the longest gap between any of the two videos, I think it's like 9:31 to 9:33, 9:34, something like that. But I think what that means is there is a period of 2 to 3 minutes where there is no video footage of the car. Is that right?
I believe that's correct, Your Honor. I would.
Okay, I'm not holding you to the exact,
Sure.
but we're talking about a couple minutes, right?
As far as the sufficiency of whether or not the passenger was in the vehicle and got out during that time,
Right.
I would posit that I believe during that gap, the officer testifies that we would expect it to be traveling this long on the route, and then it shows up where we expected it, and so that it could not have taken a break, essentially, for someone to park and then get out, and then someone else to get in.
That's the algebra that Justice Grant's going to teach me. Right?
Fair enough.
Okay, all right. But that's the point. That's
the point.
There's a period of, we know where camera A is, we know where camera B is, and it'll take, it's a long amount of time, assuming they're going 20 miles an hour, 30 miles an hour. There just wasn't time to have a significant stop. That's the point.
That's the point, Your Honor.
Okay, thank you. Thank you.
And to that point, I'll just quickly highlight that there were these unique identifiers that the officer was using to track it, and the quality of the footage as it gets into the market is pretty clear. You see the defendant getting out of the passenger side vehicle. So I would say that that is enough to identify the passenger as being the passenger in the vehicle when it parks in the market, and then those unique identifiers place it as the same vehicle. And I think it's a reasonable inference that it was the same passenger in the front side of the vehicle at the time of the shooting. I'm just going to move to the motion to eliminate unless there are further questions on that. So in this case, it's really a 401 analysis and a relevancy analysis. It is not a 403 analysis, and I would argue that the court should limit its discussion to that point. And to that point, the relevancy standard is quite favorable. It's, any tendency to show an issue in dispute. In this case, an issue was, did the defendant have access to ammunition? The ammunition found in the safe was the same type, the Blazer ammunition found at the scene of the shooting. And I would submit that that does allow for, show somewhat that that is more likely that he had ammunition. As far as the conditional relevancy, I would point to the Bright case, which says that that's really an issue for the jury. The Bright case specifically says that, the jury, the defendant is not entitled to even a jury instruction on the conditional relevancy, and yet here the defendant got one. So if there was any error, it was in favor of the defendant getting an instruction that he was not necessarily entitled to. That instruction is in transcript 3 on 125 to 126. If there are no questions on the motion to eliminate, I would quickly touch on the fingerprint expert.
I'd like
Sure.
to jump in there. Do you, well, in your brief you don't. I'm going to give you a chance to think about it again. Do you concede that the officer's testimony, specifically his testimony about the print, was error?
I do not concede that his testimony about the print was error, and I believe there's a distinction between the kind of testimony that the defendant is describing and the testimony that was actually given. The fingerprint expert said that the identification was 100% completed. That essentially is a loading bar of, we've done what we were tasked with doing. That is not that it is 100% certain that the identification is the defendant and it is correct.
Well, here's my understanding of it, and it's not altogether clear, but and I'm looking at your brief at 34, when explaining why DNA was not collected, he stated, quote, "The utilization of a forensic scientist in addition to a fingerprint analyst," and I think we can infer a DNA analyst is the kind of forensic scientist he's talking about, "would vary on the severity. Oftentimes, a fingerprint identification stops that process I think what he means is, suggests we don't need to do DNA analysis. I think that's what he means. Because you have 100% of an identification completed. Now, it's not a model of clarity. What I took that to mean was we have achieved certainty to 100% of the identification here based on my fingerprint analysis, and therefore we didn't need to do a DNA analysis. Are you telling me that's not what he meant?
My understanding, and I respectfully disagree, that my understanding of that testimony is that it is, we did not do DNA analysis in part, again, partly based on the severity, but also in part because the identification had been completed. Whether or not it was determinative or not was not what he was stating there. He states that earlier that it was, he uses the couching language that he's required to use when he's talking about how certain he is.
All right, that's actually very helpful. Thank you.
And even if the court were to interpret it that way, the fingerprint at issue is when the car is pulled over on a felony stop hours later, and the defendant is arrested in the seat in which the fingerprints are found. So even to the extent that there was error, which again I would argue there is not, it in no way prejudiced the defendant here. And if there are no further...
I have some questions.
Sure.
Just one question about the 16-inch barrel. Assistant DA McAndrews' argument on the required finding motion, she referred to the fact that if you were to believe that that is the same magazine that was fired on Pearl Street, you heard that as a Glock which is inserted into a handgun. So is she saying that although the ammunition can be used in either a rifle or a handgun, the magazine goes with a Glock handgun?
Frankly, Your Honors, it's not entirely clear. To whatever extent that that's a necessary prerequisite for it being relevant, again, that's a conditional relevancy issue which was properly before the jury. And again, they got an instruction on if you do not find that to be true.
I'm talking about sufficiency of the evidence.
Oh, I'm sorry.
So if the magazine found in the safe
Yes.
goes to a Glock handgun.
I don't believe there was any evidence in the record that the Glock magazine could only go in a Glock handgun. Even if she argued that, I don't believe that evidence was before the jury, so it wouldn't be.
And then she says something about the fact that a rifle needs two hands. And is there an inference from that video A that whoever is using the firearm is not using two hands? Is it from the width of the passenger seat, maybe?
If that inference is there, Your Honor, I could not see it with that level of clarity. I would, again, submit that it's essentially the other objects in the scene and it not being seen in a video seconds later that allow an inference of to size. If there are no further questions, I would rest on my brief and ask that you affirm the convictions.
Thank you very much. The case is submitted. We are going to break for about 15 minutes. I expect we'll be back out about 10 after.
Court, all rise. Court is open. Please be seated.
All right, good morning. We're back with the fourth case on the list, Dorsey versus City of Boston, and that is 24P 1063.
Members of the panel, may it please the court, Matthew Fogelman representing the Dorsey family, the appellants in this case. Your Honors, the City of Boston is not immune for several reasons. Number one, under Section 10B, the city here was implementing.
Actually, can I stop you? I'm sorry, and I
Sure,
apologize, and I'm very sorry for your client's family. But do I understand this correctly? If the city is immune under either 10B or 10J, that's the ballgame.
I think that's correct, Your Honor,
So
and
could
they're
you focus
immune on neither.
Okay, I hear your argument. Could you focus on 10J? Because frankly, that's the one that's, to me, the higher hurdle for you.
Focus on 10J first?
First, yes.
Sure. So under 10J, Your Honor, what we're looking at is whether there was an affirmative act. In other words, under Cormier, an act that materially contributes to creating a specific condition or situation resulting in risk or harm.
Right, and also the original cause.
And also the original cause, although the definition of original cause, as discussed in my brief and in those cases, does not mean the sole cause or a but-for cause. And that's where we get into the language that I just cited about an act that materially contributes. And so what I want to focus on, Justice Wood, is the cases under 10J that are more similar to our case and the cases under 10J that are dissimilar from our case. So the big difference, sir, is the affirmative act as opposed to a failure to act. That really, to me, is distilling it down is the key difference. So let's talk about the cases where the failure to act, and my brother is going to emphasize those, but that's different than our case. In Brum is a classic failure to act case. The school allowed assailants to come in, and the school did not take any affirmative acts, and therefore, if they did not take any affirmative acts, they did not take any affirmative acts to create a situation that led to harm. And the plaintiff in the Brum case actually claimed that the school did not do anything or did not do enough. The essence of Brum's claim is that the school had no security measures at all, as opposed to the school officials erred or were negligent in the implementation of those security measures.
Right, okay, but sorry, but in this case, I think the facts such as they are that we have are the Burke School had metal detectors, right?
Correct, and made an affirmative decision to install metal detectors.
I think that's a fair inference. But to have a metal, nobody said this out loud, but I think this is the case. A metal detector without a human being nearby is kind of useless. They have a security guard, I guess, who stands there and monitors as people make sure, A, you go through the metal detector, and B, if it beeps, they search you. I mean, I assume that's what they had.
I believe so, Justice Wood, but I'm actually not certain because we only had limited information and we pled the best information that we had.
Okay, but that's I guess the inference we're all using for now.
Yes.
And okay, so your argument is Burke is worse than Brum because they did something. That's the affirmative act. To me, the problem I have with your analogy to Brum, or the distinction of Brum, is Brum, they didn't do anything. And so there's no liability because it was a failure to act. Here, they did something, but they should have had more. And so the affirmative act of doing something creates liability. That strikes me as bonkers.
I understand your point, Justice, but let me respond in two ways. They took another affirmative act that's actually stronger than installing the metal detectors. They disabled the metal detectors at a certain time.
Right, 8:30 in the morning, right?
8:30 in the morning.
I get that, and that's...
But that is, I don't mean to interrupt you.
No, go ahead,
That is a key affirmative act, though. And to me, probably the biggest thing that distinguishes our case from any of the other cases, and why we're more like the 10J cases where there's no immunity. that is an affirmative act. I don't know why they did it. That's why we need discovery. This is much more appropriate for summary judgment. I think we would prevail on summary judgment anyway, but certainly not for a motion to dismiss. There's so much we don't know. And the Wheeler case actually makes that point of why discovery is so important in these cases. But they took some affirmative act that made these metal detectors inoperable after a certain time.
How did that incentivize or facilitate the happening of the violence?
Because the shooter, was able to bring a weapon into the building, Justice Hand, once the metal detector was rendered inoperable. And because he brought the weapon into the building, he then used the weapon. So that is a direct connection, and that is within the penumbra of the case law.
But why is that different than having no metal detector at all?
It is different than having no, and I understand both of your points. In a sense, I think what you're saying is, well, are we punishing the city for putting in a metal detector as opposed to if they just never put one in at all? I don't think it's bonkers, though, Your Honor. I think that's actually the law. So in the 10J cases where there's a true failure to act, the defendants actually did not do anything. So Barnett, SJC case, there was a decision not to erect a fence or a barrier, and someone got hurt while they were sledding. That was a true failure to act. Now, you would say, well, but if they erected a fence, then wouldn't that have been better? Well, yes, but that's not the law. That's what the SJC has said.
It strikes me that the choice to, I mean, again, we're working, I guess, with an inference, but after 8:30, the record seems to be, in the record is they stopped using the metal detectors after 8:30. What I thought that meant was after 8:30, after the kids had mostly come into school, the security guard is reassigned to something else. And that strikes me as a 10B issue, policy, implementing a policy. In other words, we've got limited resources in this world that we live in, especially running the Jeremiah Burke. And so we've only got a certain number of, you get the point, security officers. But my point is that's a 10B issue, not a 10J issue. It's taking a security officer and reassigning him is not an act in the sense of 10J. What do you say about that?
I think that's true, what you just said, but I don't know, and actually we don't know, and there's no evidence in the record that there was a security guard there that was reassigned. We don't know that.
True.
We do not know that. For all I know, there was not a security guard there at all that day. For all I know, they contracted out to a different company. Maybe the machine wasn't working that day. Maybe the security guard fell asleep. I just don't know, Your Honor.
What's the record support for my understanding that the metal detectors stopped being used at 8:30?
The record support is information that we had upon information and belief based on talking to our client and some investigation that we did, that it appears that the metal detectors were working at some point and then were not working at some other point. And I would submit that that is a negligent, I want to make this point also, not made so much in the briefs, but it is in the complaint at paragraph 36, a negligent failure to maintain premises is not subject to immunity. And that's where we get into the Wheeler case. In the Wheeler case, they talked at length about whether there was a, actually, let me just read from the Wheeler case for 1 second. Where the injury causing component is a physical defect in premises or a result of a negligent failure to maintain premises, the government entities are not afforded immunity under the discretionary function exception. Now, that's more of a 10B argument, so I know you wanted me to focus more on 10J, but I think you just mentioned 10B, so if I've just hit 10B for a second, I do think that's an important point, because the metal detector not working at a certain point of time for whatever reason is a negligent failure to maintain the premises.
Why? I mean, well, under the universe of 10J, well, first of all, we don't know, we have no information about the metal detectors other than your representation based on information and belief that they had metal detectors and they stopped using them after 8:30. The way I read that anyway was that your allegation is that they intentionally stopped using them after 8:30 because the kids have come in.
I don't know that that's true, though, Judge. And I know, I'm not trying to quibble with you. We don't have enough information, and it's not in the record that that's the reason.
Okay.
There may be classes that start at 9:30 because kids have first period off. I mean, I don't know, Judge.
Okay, but if that is the case,
But that's not what this case should be decided on, though, not on that point.
what should it be decided on?
What should be decided on is 10B and 10J. 10B, very briefly, let me just make this one point. We're talking about the implementation of a policy or plan rather than policy making or planning. It's a subtle difference, but it's an important difference. The Alake case, I think that's how you pronounce it, A-L-A-K-E, there were chaperones that were hired to supervise a party. The chaperones were negligent and the party went awry. The court said that you cannot have a claim for not having enough chaperones. No good, because that's policy making. But you can have a claim if the chaperones did a bad job, because that is the implementation of the policy. I think our case in that regard is very similar to Alake. We are talking about the ministerial, and that word is used in Alake, clearly ministerial, and that goes to the implementation of the policy. So if we look at policy making versus policy implementing, I think we get over 10B.
Right. I want to be fair to you. I agree with you that if we're in the universe of 10B, the case law is suggesting the implementation of a pre-existing plan. We don't know what the plan was. Discovery there, it seems like a good idea. But my real problem, the reason I don't think I get there, is 10J, and you've only got a little time left. And in 10J, my real problem is that the other cases that are the affirmative act, you're acting on a third party who then does the harm. The closest case for you seems to be the case about the sewage, the city of Worcester.
Yes.
But even then, they're acting on, in a very concrete way, the sewage. The sewage then goes on to do the harm. It runs on people's property. Here, the city, there's no affirmative act by a Burke employee on the shooter. There's no claim. You don't allege that they have any Burke employee has any interaction with there's a failure to act, to have any interaction with the shooter. And so to me, that is the material distinction, why this is not a 10J liability, why your claim fails. Help me understand where I've gotten it wrong.
Okay, I'll try. I think Shapiro is on point for 10B reasons, but also for 10J. The affirmative act is deciding to allow a third party's effluent to flow into the Worcester sewer system. Like Dorsey, our case, the decision to disable or make inoperable, for whatever reason, the metal detectors allows a third party to come in with a weapon and use that weapon. That is not a leap, Your Honor. In my opinion, it's a very clear connection.
In Shapiro, correct me if I'm wrong, the city of Worcester had a relationship with, a contractual relationship with the owner of the sewage, whoever had the sewage. And they were dealing with that party and in fact made a decision, we're going to let your sewage go wherever it goes. The city actors are working with are communicating with the party who owns the sewage. Here, there's no analogous communication with the shooter, the guy who does the harm. There's no allegation that the Burke people talked to the shooter.
I think that's true. I think that's true.
And is that fatal?
I don't think so. No, because, and I don't read Shapiro to say that it is fatal. So you're right, it's a factual distinction. I don't think it's fatal, though, because I think again, why do they have the metal detectors in the first place? Presumably because they know it's a dangerous school, not trying to be pejorative, but it's a tough school in a tough neighborhood. We need metal detectors. They have had crime there before, a few weeks before they had a crime. They had a shooting or stabbing a few weeks before and one subsequent as well. So we have to put these in because we need to protect the students. It's an affirmative act. We're going to put these in. Now we put them in, we have to carry out the duties non-negligently. We have to maintain the premises. You're assuming the duty, you have to do it non-negligently. So we have to maintain these premises. We have to make sure that the metal detectors are operational, that they're operable, that they're working properly, that they're staffed properly. And those are affirmative acts, and the decision to disable that for whatever reason is an affirmative act. I liken it to the other 10J cases. Dovey, Blanford, they hired a guidance counselor. That person abused students. Onofrio, they placed a patient in a rooming house. The Thies case, which came down recently, where the MBTA negligently promoted and retained an employee, that's an affirmative act. And this court said in Thies that that could be viewed as an original cause of the passenger's injury. The MBTA didn't harm the passenger. The employee that the MBTA hired harmed the passenger, and yet original cause was found. So I would just urge the court to, those 10J cases where there are affirmative acts, I think is more like this and less like Brum and less like Lawrence. Judge Sisitsky relied heavily on Lawrence, where the police officer failed to show up to protect a man who was promised protection. But that's a failure to act. The cop did not show up. If the cop showed up and then negligently carried out his duties, I would argue that's 10J. But the cop did not show up. Failure to act. So Judge Sisitsky, I think, had the right idea, but I think it was the wrong application.
I have a question for you, sorry.
Yes, Justice Grant, please.
Your client's first name, MARQUE'E?
Yes, ma'am.
It's spelled in the briefs E''E. Is that actually supposed to be an accent over the first E?
I believe it's an apostrophe, Your Honor.
Okay.
I believe so, yes.
Other questions?
No.
Anything else? All right, thank you very much.
Thank you so much, Your Honors.
Good afternoon. Good morning, Your Honors, and may it please the Court, Mauricio Vaca for the City of Boston. Mr. Dorsey was tragically shot at the hands of an assailant, a person whose sole aim was to harm him. It cannot be said how tragic this matter was, but we disagree on the 10B with my brother here. But this case can be dispensed, as Justice Wood stated, under 10J. My brother talked about this being an affirmative act. There's strong case law stemming from Brum, stemming from Lawrence, that hold and that caution against treating every failure to prevent as some affirmative act. And that's exactly what's happening here. This is a harm that occurred by the actions of an assailant who intended to harm the appellee, Mr. MARQUE'E Dorsey.
Is that the difference in your mind between this case and Shapiro?
Yes, that is the difference. You have here a situation that is separate from what the metal detectors are doing or what anything about the metal detectors. Mr. Gene Little, who was the assailant, was going to harm Mr. Dorsey with or without the metal detector. It's a situation separate from the metal detectors and security at the school. And as the Brum case has discussed, it's critical to resolve these issues early, before discovery. These are questions that have to be assessed at this stage, and the reason why is because, as Justice Wood pointed out, there's resource issues here. There's issues about government expenditure and questions on how best to allocate resources.
Understanding that, Brum didn't say it couldn't be resolved at an early stage Brum did not say it had to be decided on a motion to dismiss at the cost of a correct analysis of the allegations, correct?
That's correct, Your Honor. But here the allegations are clear as to exactly what is being sought for liability. The legislature, in its considered judgment, sought to retain immunity on the basis of third-party violent acts. That's something that the legislature considered and said, we're actually going to put that, we're going to take the efforts to put that in a statute, that failure to prevent actions are immunized. And the concept is retain immunity, because immunity exists, sovereign immunity exists until a legislature acts to waive it. So basically, 258.10, subsection 10, just says that the waiver doesn't apply. So it's important to resolve these questions early.
Is it too much of a leap to try to imagine, what I'm trying to get at is discovery. Would discovery, a deposition of a security officer who was there well, first of all, finding out in discovery whether security officers were there at the front door, and if there was a security officer there at the time that Mr. Little came through the door, and whether security officers had any interaction with Mr. Little. Is that all relevant to a basis for an affirmative act? I guess that's what I'm, yes, that's my question.
It could be, Your Honor, but the problem that the appellants have here is that they haven't pled anything of that nature.
Well, how could they? I mean, if they, what they know is that Mr. Little comes barreling through the front door as Mr. Dorsey's getting picked up by his mom and then tragically starts shooting at the whole family. That's what they know. And I guess they know maybe because from Mr. Dorsey that there's metal detectors at the front door. I guess that's a fair inference. But do they, beyond that, they don't know anything. So if there was a security guard there who actually had an interaction with Mr. Little, is that something that they should get a chance to flesh out in discovery?
They could, but the issue is that right now what we have is an allegation, a conclusory allegation, because the word proper use is in and of itself like a label and conclusion versus saying it was shut off at 8:30 or it was such and such. There's facts that can be developed pre-suit or through investigations or what have you, and speaking with the security guard, getting their phone number. There's all these facts that you can plead early on to establish a case. But what we're left with is proper use of a metal detector was not properly used after 8:30 a.m. Those are the allegations that's really the single crux of this case that the appellants are relying on. I also wanted to point out that the affirmative act issue that the appellants are raising right now, the Lawrence case also addressed. I mean, the police were affirmatively in Lawrence protecting a criminal trial witness who was who'd been promised essentially that they were going to be protected, and they held in that case that that's not an original cause.
Well, actually, it's a little bit of confusion in my mind. I think actually in Lawrence, the SJC, Justice Freed, actually reversed dismissal and said it was, or it might have been at summary judgment phase, there was a factual question whether or not the officers had promised the witness protection, and that created a legitimate dispute of fact, and therefore the SJC remanded the case, I believe, for a trial, but I'm not sure, but they remanded it to allow it to go forward. So I think that case is not particularly helpful. But the point is, if there's a legitimate question of fact about an affirmative act, then I think Lawrence says go forward and develop that. We're at a preliminary stage here. So, but
yes, I would also point your honors to the line of cases that have been cited extensively by the appellants that talk about the affirmative action being the negligent hiring and those sorts of cases, which are more clearly distinguishable as affirmative acts because you're placing a tortfeasor in the room and you have control over the tortfeasor. You're placing them in the room with the plaintiff or the appellant.
I agree with that analysis, as I tried to make clear, but then the question is, to what extent did a Burke employee put Mr. Little in the presence of this family? In other words, is it? We don't know what we don't know. That was there something that happened in the foyer of the Burke seconds before, and was there negligence of an affirmative act by a security guard? I feel like I'm wildly speculating, but that's because there's no discovery.
Right, and that's precisely what like the lines of cases regarding speculation and the standards of a motion to this on a complaint point to, which is you shouldn't be speculating, Your Honor. You should be able to tell from the complaint what exactly is being claimed. So if there are no further questions on 10J, I'd like to address 10B in the last moments. So even accepting as true and drawing all the inferences in the favor of the appellants, we also win on 10B. And that's because the questions that are being raised, what we have in the complaint, the questions that are being raised at this moment in time are how and when are those metal detectors on? And those are questions that specifically address how much and when do you provide security? Those are sort of the discretionary questions that are answered and resolved in Wheeler. And Wheeler is our strongest case on this point because it's very similar in facts, where it's a building and then there's decisions on how best to protect that building and assailants from coming in. And the court there, of course, was able to determine that those are questions that that regard resources and allocation and budgets and all these sorts of things that right now we're left with this complaint as well. We also cite Alake, which is a case that's discussed by the appellants, and same sort of questions that arise there, which is how much security through chaperoning do we provide the plaintiffs? And those are the same questions here. What we have here is a complaint that solely says the metal detectors were not properly used after 8:30 a.m.
So, but since you were talking about 10B, under Barnett v. Lynn, SJC says the exception does not include this planning discretionary use of resources, does not include the carrying out of previously established policies or plans. And so what I think that means is if there was a pre-existing policy or plan that had been created before this shooting that addressed the implementation, for example, of metal detectors and the manning of metal detectors by a security guard, and hypothetically designated that the security guard shall man this all throughout the school hours. This seems to be the most reasonable possibility. As long as school's open, there'll be a security guard there at the front door. And if that's right, then arguably the security guard leaving his post and allowing this to happen, maybe that's enough. But the point is the plaintiff entitled to discovery to find out if there was a pre-existing policy or plan about the metal detectors and the manning of that area?
Again, Justice Wood, I would say that those facts should have been pled at the time of the filing of the complaint. Those facts are public knowledge. A person can easily find out whether or not there's a policy and whether or not it's just mere implementation of that policy, and make factual allegations as to that point. Again, all we have is that paragraph 36, which says the metal detectors were not properly used after 8:30 a.m. That's all we have. And again, proper use is a conclusion.
So
It's
you
not
think under
telling us
Yannicchino that's not plausibly suggesting an entitlement to relief?
That's correct, Justice Hand. If there are no further questions on either of those issues, I'd rest on my brief.
I just have one comment about your brief. It would be really helpful if your table of cases had the cases listed in alphabetical order.
Okay.
Because when I look at your brief and think, oh, what does the city have to say about Lawrence v. Cambridge, I have to look through all the cases because they're listed in the order they're cited as opposed to alphabetical. It makes it really hard to get to your argument.
Okay. Thank you, Your Honor. I'll note that.
Thank you very much. Thank you both. The matter is submitted. Right, and the last case on our hearing list today is Reynoso versus Rathor. It's 2024 P917. Go ahead.
Good afternoon, and may it please the court. Elizabeth Clegg for the plaintiff appellee, in this matter. Honorable members of the panel, we labor at a time when the hostility toward people from other countries, toward linguistic minorities, toward people whose first language is not English, permeates every aspect of our society, and it finds its way, whether we like it or not, into the halls of our courts. That's why the rules about ferreting it out are strict, beginning with the statute that requires the court to offer an interpreter to a person whose primary language is not English.
Not exclusively to a person whose primary language is not English. It's to a non-English speaker, and that's something that the courts have interpreted, correct?
The court interpreted that as primary language not being English, but the statute states somebody who has trouble understanding and speaking English. And in the record, the appellant here has trouble understanding, speaking, and writing and reading.
You've indicated, oh, sorry, go ahead.
Should we make a rule in a case that any time a trial judge sees somebody with a foreign sounding name or who speaks with an accent, the judge should question them about whether or not they can understand English?
The court should have, certainly in this case, where the record's replete with instances which indicate the trouble that he was having both with written materials and in understanding what he was hearing. There's a point in the record at page 443 where it becomes very clearly apparent that there's and actually prior to that, at 419.
They're talking about the special verdict slip, is that correct?
No, I'm talking about the appellant's review of and hearing and understanding what the court is saying and what's being asked of him. I mean, as a result, the reason that it's so important to have the interpreter offered and not presume any kind of waiver is because there are nuances that come up in trying a case that are going to be lost on a non-English speaker. Here, there was a glaring difference between the belief that he was addressing the jury and giving his evidence to the jury and the reality that that was a closing argument. And in fact, he began and ended the trial without offering any testimony at all. That was not anybody's intention, but that is ultimately what happened.
Is there case law that, well, so first of all, I think I'm right that the plaintiff proceeding pro se never asked for help, never asked for an interpreter, right?
That's correct.
Right. Okay. So is there case law addressing that situation? A party doesn't ever ask for it, the court doesn't sua sponte offer it, and the court reverses the proceeding, the result?
Well, I think in the Gautreaux case, those are the circumstances. But the statute is clear that it states that the failure of a litigant to ask for an interpreter is not a waiver of the right, that it is the obligation of the court to determine whether or to offer the services of the interpreter. I hesitate to ask the court to establish a rule. I think this is a specific case where the need was clear. And it came through, and again, it poisoned every aspect of the proceedings in which he had a right to review juror questionnaires, to review the guide for pro se litigants, to review jury instructions, and to opine on them.
I'm sorry to interrupt you, but is there, I didn't see in your brief a list of citations to the record as to where specifically you say your client's difficulties with English were apparent. And is there, am I missing that?
There is a section in the brief that addresses that, but I can...
record sites to that? Are there record sites in there that I have?
There are
just
record
overlooked?
sites in there.
All right, my apologies.
Yes, there are page notations to the record. And if you'll give me a moment, I can quickly... The record at 142, right out of the gate, the language barrier is apparent in a colloquy with the judge over exhibit tabs. Again, this is the kind of nuanced area of language that is critical to understand when you're trying a case, but that may be lost on somebody whose language is not English, whose primary language is not English, who has trouble speaking English, even though they are able to speak the language enough to get through the day-to-day.
I have a question. As appellate judges, we're deciding this case based on a transcript. Judge Yessian had your client before him and could hear him and see his demeanor, hear his accent. You could also hear and see the defendants and plaintiffs in counterclaim. How can we second guess on this record what the trial judge did?
Because there are specific citations of the record in which the appellant is saying, I do not understand what's happening. I need a moment. One of them is at 142. There are several of them, as well as his affidavit, in which he indicates that he speaks heavily accented English that can be difficult for people to understand, and he has trouble understanding and reading English, and that's at page 11 in the record. It's not only is it not his primary language, but it is a language that he struggles with, according to his affidavit, under the best of circumstances. But again, at trial, there are several citations to the record in which he is saying, I do not understand what's going on. There are also several notations in the record the transcriber had trouble understanding what he was saying. And so there was no ability, and again, the statute is not discretionary when it comes to the issue of waiver. It does not include in it a definition of a non-English speaker, but I think the Gautreaux case includes that, and I think this appellant clearly fits the definition of a non-English speaker that the statute speaks to. Offering the interpreter for assistance with reviewing the written documents, reviewing the guidelines for pro se litigants, helping to understand that the difference between testimony and argument would have, as I indicate in my brief, would have been transformative in this case. Coupled with the other errors having to do with peremptory challenges and instructions to the jury, this is a litigant who, as sophisticated as he may be, really never had a chance. Even in his status as a pro se litigant, where, we all understand that pro se litigants are supposed to be held to the same standards as lawyers. Everybody is told that, but they're not supposed to be punished for being pro se litigants. They're not supposed to be subject to anything like an eye roll or criticism for that, or perceived criticism. And there are instances in the record that I pointed out in my brief that it was communicated to the jury criticism of this pro se litigant was communicated to the jury. And that's why I cite the Tunnel case where, and the Saposnik case for that matter, where the law is established that people should not be punished for pursuing their case pro se. It can be burdensome.
Well, when you say people should not be punished, it seems as though a lot of the cases on which you're relying are criminal cases. Can you explain to us why we should import those holdings to a civil case like this one?
Certainly. Because Article 12 and Article 15 don't speak in terms of the Commonwealth and the defendant. They call, what they say is subjects. That's all of us. Because the 14th Amendment doesn't speak about defendants and prosecutors, it speaks instead of persons. So these trial rights that are implicated here and that were denied to the appellant belong to all of us. And certainly under the 5th and 14th Amendment, under Article 12 and Article 15, the consequences that he's faced have been devastating to him. So, and unanticipated by anybody. And when you're in trial work, we do not expect surprises, and there's a reason for that. And so when there's a surprise like this verdict coming so quickly, it establishes that there is a problem. There were many, many problems here, and they were, they're a cascading series of problems that really do begin and end with the language difficulty, but certainly not the only thing.
The biggest problem I'm having is waiver. Civil waiver is a serious thing, and I understand you're trying, it feels like an end run around waiver using the statute, which says this can't be waived. But the problem is the plaintiff never asked for an interpreter. If you could, I've been running around the transcript here trying to find you keep saying, I've cited the transcript where he said, I don't understand. RA 323 is page 142. You cited RA 142. That's not what you meant. I think you meant RA 142, RA 323, where he makes an objection that doesn't, and then the judge says, no, you're not talking about something. We're talking about different things. And he says, oh, I'm sorry. He never says there, I don't understand. Is there any place in the record, a record site, where he actually says, I don't understand what's happening, or the equivalent of that? Because what you've given us so far, as far as I can tell, that never happens.
If I could have a moment, because I do believe I cited it in my brief. If he does not say the words, I don't understand, he makes clear that I don't understand.
Right. I didn't get that impression when I didn't always understand him, but I didn't, which might be irrelevant, I don't know, but I never found a spot in the record where he said, I don't understand what's going on, I need help.
Well, he says at one point at RA 145, I don't understand tab, I do not understand tab, I apologize. And the judge says, the tab is the number. Mm-hmm. You're talking about the emails. And he says, oh, okay, the tab. And then they go on, and he understands that the tab means the number.
And again, that's at the very beginning, and that's what I was mentioning when I began my argument. He was not in a position to interpose any objections, to understand the difference between, as I said, between argument and testimony, and to advocate for himself. When he was, he walked in confident that he would be able to do that. He would have an opportunity to be heard.
Is that a function of his language, though, or is it a function of him not being a lawyer?
No, it's a function of his, now my brother, my esteemed brother will say it's a function of him not being a lawyer. But I am certain it's a function of his language because, again, the difference between argument and evidence is something that begins with the words. And with that, I'll rest on my brief and record appendix.
Thank you very much.
I thank the panel.
Good afternoon, Your Honors. May it please the Court. My name is Mark Hamer, and I represent the appellees ASHWANI and Vicus Rathor. Especially with how my counterpart started, I want to lead with this. My clients speak English as their second language, and they testified at trial in their own heavy accents. This Court should affirm the judgment of the Superior Court. The trial below was fair, the jury's verdict was supported by the evidence, and the legal issues the appellant now raises were either waived, not preserved, or lacked merit. The appellant argues that the trial court was obligated to appoint a Spanish interpreter even though he never requested one. That argument is contrary to the statute and the record. Under General Laws, Chapter 221C, Section 1, the right to an interpreter is triggered where a party has difficulty in speaking or understanding the English language. Here, the trial judge reasonably concluded that Mr. Reynoso did not have such difficulty. The judge was in the best position to evaluate that. Appellant participated in pretrial conferences, handled filings, interacted with the court, and responded to procedural questions without confusion. He affirmatively acknowledged that he understood the judge's instructions. And while an interpreter was available at his deposition, he proceeded in English. I want to go over this specifically. At the deposition, the interpreter was offered for my benefit. At the time, the appellant was represented by counsel, and he contacted me letting me know that at times his client would be difficult to understand or might be difficult to understand. And so I, on my own, got an interpreter involved. The interpreter was on the line during the deposition, was not used once, and the appellant proceeded throughout in English. I also want to point out, and this is in the record, the appellant chose to speak English with this group of people he was doing business with. All of his emails are in English. Granted, broken English, but it was understandable. And although I went into that deposition prepared for it, possibly that I would have to use the interpreter, hey, can you speak Spanish to the interpreter who can then speak to me in English, I understood the appellant. The court must ensure fairness, not guess at language barriers. If there are no questions about the interpreter issue, I'll move on to the jury issues.
I just confirm that the information you gave us about the reason for the interpreter, at least the detail level, is not part of our record.
It's not part of your record.
Thank you.
The deposition transcript was offered as part of my supplemental appendix. The appellant raises for the first time on appeal claims of bias in jury impanelment and error in jury instructions, but at no point during trial did he object or ask for voir dire on national origin bias, nor did he challenge any peremptory strikes as discriminatory. Appellant has not articulated what was unfair about this jury, not the people that were excluded, but the jury itself. It's more important to look at the profile of the jury that served rather than those who were excluded. What was the composition of the jury, not who was excluded? The appellant has not proven that there were no jury members who spoke English as a second language or who were of other national origin. Moreover, this isn't a national origin case. This is a case about invoices and receipts. And again, I want to emphasize my clients also were of Pakistani descent. Had any issues been raised, both myself and the trial judge would have had an opportunity to correct it. Under Commonwealth v. Soares, a party challenging peremptory strikes must object and establish a pattern of discriminatory use. That did not happen here. The appellant has therefore waived these claims, and the record offers no basis for finding error. Likewise, he did not object to the jury instructions, which followed standard form as established in the Felon case, P-H-E-L-A-N. Unpreserved objections to jury instructions do not support reversal absent a miscarriage of justice, which this record does not reflect. The jury's verdict was supported by the evidence. The jury heard substantial and credible evidence that Mr. Reynoso failed to perform as promised. He committed to completing a soccer field but left the project incomplete and in poor condition, which rendered it unusable for rentals. The appellees incurred significant costs to correct the deficiencies and documented business losses. Their damages were supported by those invoices, tax returns, and testimony. By contrast, the appellant failed to produce receipts for key expenses and notably did not testify at trial.
Was there any motion for a directed verdict at any point?
Not that I recall. Not that I recall, Judge. The jury was entitled to credit the appellee's evidence and return a verdict accordingly, which they did unanimously.
I reviewed the docket and didn't see anything. Was there, after the jury's verdict, the jury's verdict is read and then the court essentially adjourns, was there a motion for judgment notwithstanding the verdict or a pro se version of that? I looked at the docket. Was there a Rule 60B motion?
There was no such thing, Your Honor. My view is that the appellant acted the same as any English-speaking pro se litigant, or for that matter, a novice attorney who could make errors in the process. And when he expressed, at times when he did express some misunderstanding or when there was a pause to try and help him understand what was going on, it all had to do with process. He was not holding up his hand saying, "I don't understand English." He was not understanding the process that was new to him, and that undoubtedly would have been difficult. He also knew that he had the benefit of counsel if he wanted one. He made a very specific choice not to be represented. He had it earlier in the litigation. The case started with him represented by counsel. He cited difficulty with paying or justifying the expense. And he explained that. He even explained it in his closing argument, why he was proceeding without counsel. The appellant assumed those risks of self-representation. He chose to represent himself, and the trial court made accommodations where appropriate, but was not obligated to provide special treatment. The appellant refused settlement offers, declined to stipulate to joint exhibits, and did not present testimony in his own case. These were strategic choices. They do not entitle him to a second bite at the apple. So in sum, the appellant had a fair opportunity to present his case. The trial court committed no reversible error. The jury reached a verdict based on competent evidence. And so I respectfully ask this court reaffirm the judgment below.
The record appendix submitted by the plaintiff has an affidavit that's dated September 2024, and the caption on it is for the appeals court. As I understand it, that wasn't actually in the trial record. That's something that's being submitted to us on appeal for the first time.
That's correct.
Okay.
And again, had issues been raised in real time, it would have given me an opportunity to respond as well as the trial judge. We could have responded, but because these are all being raised after the fact, it's why we're here, it makes it difficult to look back.
Thank you very much.
Thank you, Your Honors.
The case is submitted. And that concludes today's sitting. The panel is very grateful to the security staff, the court officers who have been here today, to our clerks, and particularly our recorder and timekeeper, and to the very capable and committed attorneys who have appeared here today. Thank you all very much.
All right.